Get ready. Start. 15. The single judge as well as the division bench have primarily non-suited the appellants on the ground that the regularization of the appellants was on account of collusion between the appellants and the members of the committee. Stop. However, at the cost of repetition, we will state that the report of the committee under the chairmanship of the additional district judge is mainly on the basis of the circular issued by the Registrar General of the High Court dated 5/11/2009. Stop. It is further to be noted that by the time when the cases of the appellants for regularization had come up for consideration before the committee, the judgment of the Constitution Bench of this court in the case of Umadevi Supra had already been pronounced. Stop. In this said judgment itself, the Constitution Bench had provided that as a one-time measure, the state should take up steps for regularization of the employees who had rendered the services for a period of more than 10 years. Stop. It is further to be noted that similarly circumstanced employees in the employment of the state of Uttar Pradesh who were appointed on daily wages and contractual basis had approached the Allahabad High Court praying for regularization of their services. Stop. The single judge had dismissed the writ petitions which orders were affirmed by the division bench. Stop. Para 16. Another aspect that needs consideration is that during the pendency of the petitions, the rules with regard to regularization were amended, which provided cut-off date of 31/12/2001. Stop. Undisputedly, all the appellants were appointed prior to 31/12/2001. Stop. The change in a position of law ought to have been taken into consideration by the High Court. Stop. It is not in dispute that all the appellants were appointed prior to 31/12/2001. Stop. Undisputedly, the appellants were continued in services from 1/8/2006 on account of interim orders passed in the writ petitions. Stop. However, the selection process in which the appellants were permitted to participate could not see the light of the day as it was subsequently cancelled in 2008. Stop. As such, as a matter of fact, when the appellant's case was considered for regularization by a committee under the chairmanship of additional district judge, the appellants had in fact put in service almost for a period of 12 years. Stop. As such, apart from the circular issued by the Registrar General of the High Court dated 5/11/2009, the appellant's cases were also required to be taken into consideration in view of the exception carved out in the case of Umadevi Supra. Stop. We find that the committee under the chairmanship of the additional district judge had rightly submitted its report dated 12/7/2012 and the then district judge had rightly passed the order of regularization on 9/11/2012 granting regularization from 1/6/2012. Stop. We find that while considering the representation of some of the employees for promotion, the successor in the office of the district judge could not have annulled the order of the regularization of the appellants, which was done after following the proper procedure. Stop.